A lot of families are being given dangerously incomplete advice about Medicaid planning, and they do not realize it until years later when it is too late to fix the problem. They are told things like, don't worry, your parent can still qualify for Medicaid and keep the house. And technically, that can be true. But what most families are never told is that qualifying for Medicaid and actually protecting the house for the next generation are two very different things. What makes this even worse is that many attorneys never go beyond the initial approval process. The entire focus becomes getting the person onto Medicaid as quickly as possible. Once the approval letter arrives, everyone acts like the problem has been completely solved. Meanwhile, nobody is talking about what happens 3 years later, 5 years later, or 7 years later, when a caseworker asks the wrong question to the wrong family member, and suddenly everything starts collapsing. And that is exactly what happened in a case that still bothers me when I think about it. I dealt with a situation involving a woman who had stepped up to help care for her elderly aunt. Like so many families, she was trying to do the right thing. She was not trying to hide money. She was not trying to cheat the system. She was trying to preserve the one thing that mattered most to the family while still making sure that the aunt received the care that she needed. The family home had been there for decades. Holidays had been celebrated for a couple of generations. Thanksgiving dinners, Christmas gatherings, cookouts, birthdays, family photographs, memories stretching back all the way to when that woman's grandparents were still around. The house itself was not worth a fortune. In fact, it needed repairs. But emotionally, to that family, it was priceless. And from the beginning, she had been told the same thing that families hear all the time. If you handle this properly, your aunt can qualify for Medicaid and still keep the home as her primary residence. So she trusted the Medicaid office and she trusted the process. For years, she did exactly what she believed she was supposed to do. She handled the spin down properly. She maintained records. She followed the rules. She made sure the finances were handled correctly for her aunt. The aunt ended up spending everything down and then get on to Medicaid for several months. And the family believed they had successfully protected the home while still obtaining the care that the aunt needed. Then one day, a few months into Medicaid, the caseworker called that niece and asked a question during a conversation, not some dramatic hearing, not during a lawsuit, just a simple question over the phone at what sounded like a routine discussion. Oh, how is your aunt doing? Is she doing okay? Well, she has good days and bad days. Do you think she's ever going home? And the niece answered honestly, no, I don't think she's going home. That was it. A few days later, the family received notice that Medicaid benefits would be terminated unless the house was sold and the proceeds spent down on care. Think about how devastating that must have felt. Years of carefully following the rules, years of believing the home was protected, years of trying to preserve the center of the family's history, and suddenly the entire plan starts unraveling because one answer during one conversation. That story perfectly illustrates one of the biggest misunderstandings in Medicaid planning. The actual primary residence rule is not really about whether a doctor thinks the person can realistically return home. It is not necessarily about whether the family believes returning home is medically possible. The issue is often whether the Medicaid applicant, the person receiving care, subjectively intends to return home. That distinction matters enormously. The theory behind the rule is that Medicaid generally does not want to destroy someone's hope by forcing the immediate sale of their residence. In other words, the government is not supposed to say, you are never going home again, so sell the house immediately. If the person still intends to return home someday, even if that possibility is remote, the property may continue qualifying under the primary residence exemption. But families unknowingly destroy these cases all the time because they do not understand how sensitive the issue becomes. One casual statement by a child, caregiver, or agent under a power of attorney can create catastrophic consequences. That is one reason my office uses a document I almost never see other attorneys use. In appropriate cases, we have the client sign an affidavit of intent to return home. The document specifically confirms that the client intends to return home and that no family member, caregiver, agent under a power of attorney, or other individual has the authority to make statements contradicting that intent to Medicaid or to any government agency. Some people initially think that sounds overly cautious until they understand how these cases actually work in the real world. And this is where people need to understand something very important. The phrase, "the house is exempt," does not mean the house is automatically protected forever. Those are two different concepts. A person qualifying for Medicaid while retaining the home does not necessarily mean Medicaid cannot later pursue recovery against the property. In some situations, keeping the home in the individual's name may not be the best strategy in the first place. Depending on the timing, the health issues, the value of the property, and the overall family situation, an irrevocable property trust may be far stronger long-term planning as a tool. But many families never even hear about those options because the planning discussion focuses entirely on that immediate qualification rather than long-term protection. And that is the real problem with a lot of Medicaid planning advice online. People hear simplified phrases like "Medicaid cannot take your home" or "the house is protected" without really understanding the conditions and the limitations, the estate recovery rules, the timing issues, or the planning traps that exist underneath those statements. Proper Medicaid planning is not just about getting someone approved next month. It's about understanding how these rules operate over many years. It's about protecting the family from avoidable mistakes. It's about recognizing that the biggest danger is often not the obvious crisis people see coming. Sometimes the real danger is the small misunderstanding, the casual conversation, or the incomplete advice that quietly destroys years of planning long after everybody believed the problem had already been solved. If you want to learn more about Medicaid planning, long-term care planning, and some of the mistakes families make without even realizing it, please check out my free course at freemedicaidcourse.com. You can also find additional videos and resources through the Plain English Attorney YouTube channel. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.